My name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. I want to talk about hidden assets. It's always a thing that comes up. Hopefully, the hidden assets are ultimately discovered while the case is still pending. And if that's the case, the court can sanction the parties, the court can award the asset all or in large part to the other party. The court, like I said, can order attorney fees, can do all sorts of things. But what happens if the divorce is over? And a year later, after the judgment of divorce has been entered into, you discover that there was a hidden asset. Somebody failed to disclose that there was, something of value, and it would have to be of value, and you were entitled to half of it. And they say, oh, well, too bad. You have a right to go before the court to move to amend and or set aside the judgment on the basis of fraud. That is to say that all the parties disclosed that all the assets were before the court. And if somebody deliberately misrepresents themselves before the court, they lie, and they say that there was, only these assets and nothing more, and that's the marital estate, and it turns out that they deliberately withheld that information, the court can set aside the judgment, can modify the judgment, can award you the asset. I don't mean a split of the asset. The court has the authority and the discretion to award you the whole asset that was concealed. The court can also award sanctions and attorney fees and all sorts of things it has at its disposal in the event that you discover this. But you got to make sure of a couple things. Number one, it's going to cost a lot of money to do this. And while the court may order attorney fees because it's not your fault, expect to have to pay up front, and maybe you'll get a reimbursement. But you can't expect to call up some law firm and say, well, there's this allegation that I want to make, and I expect that the other side will pay for it. Attorneys aren't going to do that. In most cases, they're going to require you to pay $4,000 or $5,000 up front, and maybe you'll get it back. Maybe. So number one, you got to realize that that's the case. And therefore, it's got to be something of value. It's got to be something that justifies turning everything upside down. If it is something of very limited value, you got to ask yourself, is it worth all this time? But if it's a piece of real estate and something that's significant, or an expensive, classic vehicle of some sort that has a big value that got hidden away somewhere so that you wouldn't touch it, you have to bring that to the court's attention. Follow the appropriate motions. Your attorney will ask for interest, costs, attorney fees, set aside the judgment, modify the judgment, whatever he or she thinks is appropriate. But that is the remedy that you follow if somebody deliberately withheld an asset and the judgment's already been entered. If you have any questions about that, reach out. We'll be glad to help you out.